All right, in week 10, we're going to look at chapter 17, where we cover probation, parole, community corrections, and fines. So, probation and parole are different. There are some things that they have in common. There's some differences. Similarities include that they are both part of the sentencing phase. They occur in the community. Both have offenders under supervision by trained officers, and both have offenders legally placed under conditions or restrictions on their release status. Differences: they have different functions. Probation is judicial, and parole is administrative. The timing of probation and parole is different too. Probation occurs instead of confinement, while parole follows a period of confinement. Revocation process: for probation, it's by the court, and by parole, it's by the paroling authority. So one type of probation is called suspended execution. This is imposed by the court. Basically, the court imposes a sentence of jail time or prison and then suspends that sentence with the person being placed on probation. And if they break the terms of their probation, they may end up with that sentence. Maybe suspended imposition of a sentence. There's no set time of imprisonment. However, if the person violates the probation, the court may impose any sentence that might originally have been imposed. Both types of probation have specified durations. Probationers typically have a supervising officer, and some of the things they need to do are have regular visits or reporting, and the degree of supervision could vary from minimal to intense. Parole, or release to the community after serving time in prison, is determined by the paroling authority. Ordinarily, a person has a hearing before that authority. The hearing occurs at the prison before either the members of the parole authority or its hearing examiners or parole officers. And when it's done by a hearing examiner, the report is prepared and forwarded to the paroling authority for a decision. Parole eligibility: by sentencing statutes where the court imposes a sentence within a range specified by legislature, such as 1 to 5, with the 1 year being the eligibility date, or the earliest the defendant could be released on parole. When courts only impose the full term date of the sentence, such as 5 years, parole eligibility is then established by some formula, such as 1/3 of the sentence set by the parole law. It may even be indeterminate, where the court imposes a single term, such as 5 years, and the inmate immediately is eligible for parole. Release is at the discretion of the parole authority. Parole eligibility might be set by state statute or might be specified as part of the sentence imposed by the court. For example, 15 years to life. In some cases, it might be a non-parolable offense, or parole may have been eliminated completely. In 16 states, this is a while ago, they abolished discretionary parole for all inmates. 4 other states had abolished it for certain violent offenses or other crimes against a person. The federal government also has abolished parole. And abolishment does not mean the end of parole authorities, as parole continues for those sentenced prior to the abolition of parole. There can be good conduct allowances. It's subtracted from the full date of the sentence and in some instances from the parole eligibility date. If the inmate is not released on parole, then release occurs when the good time date is reached. Probation or parole supervision is an important issue. To enforce supervision, there's a power of revocation of the release status. It occurs when the supervising officer makes a negative report, which may recommend revocation. For probation, court reviews the report and decides whether probationer's actions are serious enough to terminate the probation. If that's the case, then the court can impose the original sentence or any part of it that was imposed and suspended. Revocation: if the court suspended imposition of any prison term at the original sentencing and placed the offender on probation, then upon revocation, The court may impose any length of sentence to prison that could have originally been imposed. If the probation is revoked, a probationer goes to prison to serve the court specified term. For parole, the negative report goes to the paroling authority, which has the revocation authority. If a decision is made there to revoke, then the person is returned to prison to serve out the balance of the sentence, computed in accordance with the laws of the state. Here's some cases. It's not all the cases in your chapter, but here are some main ones. Joan v. Cunningham, a Virginia parolee raised the question of whether he could go into federal court and challenge his sentence under federal habeas corpus statute. The Supreme Court agreed to decide whether a parolee is in custody within the meaning of the federal habeas corpus statute and the Constitution. The court held this could occur if the parole conditions significantly restrain the inmate's liberty to do those things which free men are entitled to do. The conditions significantly confine and restrain his freedom. This is enough to keep him in custody of the parole board within the meaning of the habeas corpus statute. Morrissey versus Brewer, 1972. Iowa inmates' parole was revoked by the parole board following its review of the parole officer's report. The board of parole ordered Morrissey to be returned to prison. The inmate challenged the revocation of his parole under habeas corpus on the grounds that he was not given a hearing. The Supreme Court looked at whether the inmate is entitled to due process, that is, some type of hearing, before being returned to prison by revocation of his parole status. And the court held that there was a liberty interest within the meaning of the 14th Amendment. It held that the liberty of a parolee, although indeterminate, includes many of the core values of unqualified liberty, and its loss inflicts a grievous loss on the parolee and often on others. The court set forth the minimal requirements needed for parole revocation. The first thing is a preliminary hearing. That's to determine whether probable cause or reasonable ground exists to believe the person's acts would constitute a violation of the parole conditions. The hearing needs to be done by an impartial party, and advance notice needs to be given. The parolee must be allowed to appear and speak on his own behalf or her behalf. The opportunity to bring letters, documents, or individuals who can provide the hearing officer with relevant information. And at the parolee's request, the opportunity for questioning of a person who has given adverse information on which revocation may be based. A hearing officer must make a summary or digest of the hearing. A hearing officer should determine whether there is a probable cause to hold parolee for a final decision. The hearing officer should state the reasons for his determination or her determination and the relied upon evidence. After that prelim hearing and within a reasonable time, there must be a final hearing. The final hearing determines whether the facts warrant revocation. A parolee must have an opportunity to be heard and to show, if he can, that he did not violate the conditions, or if he did, that mitigating circumstances suggest the violation doesn't warrant revocation. Minimum requirements of that final hearing: a written notice, disclosure to the parolee of evidence against them, opportunity to be heard in person, present witnesses, and documentary evidence. The right to confront and cross-examine adverse witnesses, unless there's some good cause for not allowing that. A neutral and detached hearing body, such as a paroling authority, and a written statement by the fact finders as to the evidence relied on and reasons for revoking parole. In Gagnon v. Scarpelli in 1973, Scarpelli pled guilty to armed robbery in Wisconsin, received a 15-year prison term. It was suspended and he was placed on probation for 7 years. He was allowed to go to Illinois to reside. Later he was arrested in that state for house burglary, so his probation was revoked by Wisconsin without any hearing. He was sent to a Wisconsin prison to serve the 15-year term he originally was imposed. He challenged that revocation by petitioning for writ of habeas corpus. He was paroled prior to the case being decided, but the court held this petition was not moot because he's still under the restraints of his parole. The Supreme Court addressed a couple issues. The first one was about due process, and the court relied on these two earlier decisions. Then the court also decided the issue of a right to counsel in these type of revocation hearings, and the court held that there was a right to counsel in limited circumstances when when the charges are contested or there's a substantial mitigating reason for his violative conduct and those reasons are complex or difficult to present. The court didn't see a right to counsel when a person is convicted of another crime or admitted to a crime. A probationer or parolee may want to provide mitigating reasons why revocation is not appropriate. These reasons of the court ordinarily are not so complex as to require counsel. In practice, as a matter of reasonable precaution, courts at most probation revocation proceedings, the parole boards at most parole revocation proceedings typically allow counsel to appear. Martinez versus California, 1980. Thomas was convicted of attempted rape, sentenced to 20 years with a no parole recommendation. After 5 years, he was paroled. This was done in spite of Thomas's record and warning in his record that he was likely to commit another violent crime. 5 months later, he tortured and killed a 15-year-old girl. Her family sued the state and its parole authority, claiming the girl's life had been taken without due process of law and that the paroling authorities were liable for the wrong decision in releasing Thomas. State statute in that case provided that government officials were not liable for any injury resulting from a decision to release a prisoner or parole on parole or from determining the conditions of parole or whether to revoke parole. It was held to be a complete defense, giving absolute immunity from suit for damages. And the Supreme Court upheld the legality of that immunity statute, holding it furthers a policy that reasonable lawmakers may favor. It allows the parole board to take greater risk in making decisions than they typically would. Victim's family also filed a 42 U.S.C. 1983 action claiming a constitutional violation of the victim's right in depriving her of her life without due process. The court held that the action of Thomas 5 months after his release can't be fairly characterized as state action. Her life was taken by the parolee. In no sense was he an agent of the parole board. And the victim's death is too remote a consequence to have them be civilly liable. As a general comment, action by a court placing defendant on probation is even more clearly immunized from suits for damages. Judges have absolute immunity from lawsuits arising for their judicial decisions. In Jago v. Van Curen, Van Curen was sentenced to 6 to 100 years with parole eligibility in 1976. Ohio passed a shock parole statute allowing earlier parole of first offenders who had served at least 6 months in prison for nonviolent crimes. Van Curen was approved by the Ohio Adult Parole Authority for early release in 1974. Shortly after the interview, the parole authority learned the inmate had not been truthful in the interview or parole plan he'd submitted. He said he had embezzled $1 million, which was actually $6 million. He said he planned to live with his half-brother when released, when he really wanted to live with his homosexual lover. The parole board rescinded his earlier actions and continued the case to a later date. The inmate had no hearing with regard to the parole rescission. The Supreme Court held there wasn't any entitlement to a hearing. It doesn't doubt that he suffered a grievous loss from the rescission, but reject a view that any such loss visited upon a person by the state is sufficient to invoke the protections of the Due Process Clause, and cited Greenholz and Dumbshot as saying that the Ohio law provided no protected liberty interest. In Moody v. Daggett in 1976, Moody was on parole from a federal rape conviction, was sentenced to a new 10-year term for manslaughter and second-degree murder. While serving these terms, the U.S. Board of Parole issued a warrant charging him with a violation of parole release terms. The warrant was lodged as a detainer. Moody asked that the warrant be executed to allow for parole violation time to run concurrently. Parole board denied the request. Moody filed a habeas corpus petition. The Supreme Court held that there was no illegal loss of liberty, that Moody was not entitled to immediate parole revocation hearing. The court held there was a good reason for the board to defer its decision and consider Moody for release or revocation of parole when he finished his current sentence. The court said it allows the authorities to make a more informed judgment on whether or not to revoke the probation or parole status of the inmate. The court also noted that the loss of liberty as a parole violator doesn't occur until the parolee is taken into custody under the warrant. In Smith v. Doe in 2003, this case, and there were some other cases, looked at the issue of government oversight, even after the time for the crime had passed. This one concerned an Alaska Sex Offender Registration Act, and here's some specifics about the registration. Required periodic verification of submitted information. Some non-confidential information would be available to the public. The Act's registration notification requirements were retroactive. The Doe respondents and Smith were convicted sex offenders. They'd been released from prison, completed sex offender treatment, and their convictions were before the Act was passed. So they brought a suit under 1983 asking that the Act be declared not applicable to them as a violation of ex post facto clause in the Constitution and of due process under the 14th Amendment. The Supreme Court saw the main question as whether the legislature meant to establish civil proceedings, and if they did, the question becomes whether the statutory scheme was so punitive in purpose or effect as to negate the state's intent. The court in the Smith v. Doe case held for the government. The intent of the state legislature was the protection of the public. The Act mandated no specific procedures, leaving up to the Department of Safety. And the department was responsible for enforcing both criminal and civil regulatory laws. The Act's statutory scheme was seen as not punitive. It had a legitimate non-punitive purpose. It advanced the interest of the public by alerting people of the risk of sex offenders in their community. Nor was it too broad. It applied to all convicted sex offenders without regard to their future dangerousness, the duration of the reporting requirements, and the wide dissemination of the information. The court held its role was not to determine whether the legislature made the best choice to address the problem it wants to remedy, but whether the regulatory means chosen are reasonable in light of the non-punitive objective. And the court held that the regulatory means chosen were reasonable. Near the end of the chapter, they talk about community corrections as a broad concept. Encompasses all types of sanctions and sentencing arrangements that allows an offender to remain primarily in the community. It could include things like probation, parole, pre-release centers, halfway houses, community service and fines, restitution, furloughs, work and study release, and electronic monitoring. Fines are another type of punishment, one of the oldest kinds of sentencing, also one of the most common sanctions for minor offenses. For serious offenses, particularly those that involve some kind of financial gain, fines might be combined with some other sanctions. In Williams v. Illinois in 1970, Williams was sentenced to 1 year in jail and a $500 fine for petty theft. He wasn't able to pay the fine. Under Illinois law, he was to be kept in jail until he worked it off. The fine was worked off at a rate of $5 per day. That meant he had to serve 100 days longer in jail. Extended sentence also was 100 days longer than the maximum jail sentence authorized for the crime. And so the Supreme Court held it violated the Equal Protection Clause to require an indigent defendant to serve longer than the most that could be required for a non-indigent defendant. In Tate v. Short, the court extended its protection of indigent defendants to, in fine cases, to traffic offenses, in situations where there was no authorization of confinement. This case in Tate v. Short, he was given a fine which he was unable to pay. He was ordered to the prison farm to work it off at $5 per day. And this is basically debtor's prison, or incarcerating people unless they pay the state. The court held this was impermissible discrimination against indigent defendants in violation of the 14th Amendment. Here, the confinement was ordered solely due to the person's indigency, and this was an equal protection violation. The Supreme Court's basically abolished the old practice of working off fines. Sentences such as $100 or 10 days are no longer allowed. In Bearden v. Georgia in 1983, Bearden was placed on probation with a condition he pay a fine of $500 and $250 in restitution. He paid $200 toward the fine but lost his job and couldn't pay it. When the balance came due, Bearden told his probation officer he was going to be late with his payments because he couldn't find a job. He went before the court for a revocation hearing. His probation was revoked, and he was ordered to serve the balance of his probationary term, about 3 years in prison. The court, upon getting the case, forged a new rule, one intended to take the competing interest into account. It said an indigent inmate should not be excused from punishment, including imprisonment, if he willfully refused to pay, but if the person had made good efforts to pay the fine and could not do so. It's fundamentally unfair to automatically revoke probation without considering whether adequate alternative method of punishing the defendants are available. And only if alternative measures are not adequate to meet the state's interest in punishment and deterrence may the court imprison a probationer who has made sufficient bona fide efforts to pay. This case was sent back to trial to the trial court to consider the new rule, taking into account the indigency of the probationer. Other sentences that avoid confinement, orders for community service and other creative orders. These require certain activities or contributions by the defendant in lieu of imprisonment. Electronic monitoring. This could be used in conjunction with probation or parole, as well as by itself. And basically, electronic monitoring keeps track of a defendant's location. Drug testing. That might be a condition of probation. It could be an independent kind of sentencing run by an entity to monitor the drug-free status of the defendant when that is specifically ordered by the sentencing court. Some other programs that release a person from prison to go into the community with special conditions and with the prison constraint still hanging over them, things like parole, furloughs, work release, study release. Legal questions are raised by some such community corrections activities, but they're pretty small compared to those of prisoner rights. There's been no Supreme Court rulings at the time of your textbook or significant constitutional rulings on these type of programs, except for the cases that we talked earlier about probation and parole cases. What does exist comes from those denied participation or termination from participation because of some failure on their part. The significant concern in community correctional activities would seem to be to ensure that these programs are available to all offenders without regard to race, gender, or other unjustifiable distinctions, basically equal protection. Placing inmates into a work or study release or furlough or on parole is a discretionary function. Placement considerations should be tied to the criminal history and past behavior of the offender, along with their prospects for success in the community. Apart from the impermissible factors of discrimination, program decisions should be based on eligibility and risk criteria, along with correctional judgment.